Welcome. This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Thank you. Now, to get us underway with this program, I'm very much looking forward to this panel, and I hope all of you are as well. I will introduce our moderator, Justice Lambden, and then I will hand over the reins to him to introduce our 2 illustrious speakers for this afternoon. So Justice James Lambden has been an ADR Services Inc. panelist for 10 years at this point, following a practice of nearly 4 decades as a trial court lawyer, trial court judge, and associate justice of the California Court of Appeal. He has represented clients throughout the state in cases involving all kinds of things: commercial contracts, construction, security transactions, employment, businesses, international corporations, small organizations, and as a appellate justice, he enjoyed working on the Court of Appeals and presiding over any number of different assignments throughout his illustrious career. And now, since joining ADR Services Inc., he has continued to do this wonderful service as a full-time neutral, where he engages in complex dispute resolution. He serves as a mediator, arbitrator, referee, mock arbitrator, appellate consultant, and works in disputes ranging across the breadth of civil matters. So thank you, Justice Lambden, for moderating for us today, and I will hand the reins over to you.
And thank you, Katie. I've been looking forward to this for some time, particularly since 2 of my dearest friends are going to be with me this morning. I started to say my old friend, Justice Ming Chin, but my dear friend, Justice Ming Chin, has enjoyed a decorated career, literally decorated. He has medals. And his career has been defined by public service, including his 24 years on as an associate justice on the California Supreme Court. Moreover, he is respected nationwide among his peers, not simply for his intellect and his fine character, but also for his contributions to the judiciary, and especially through the opinions he's written. He's known for a prolific output of landmark decisions in civil and criminal matters, drawing upon his experience in civil business litigation, where I met him. He also has served in family law and criminal law. I should say that he was a formidable attorney. I should know because I litigated with him and against him. He was always a gentleman. As former chairman of the California Judicial Council's Court Technology Advisory Committee and Science and the Law Steering Committee, that's a mouthful, he wrote some of the first opinions about DNA, which were recognized around the nation, and helped understand the use of DNA in court proceedings, particularly in felonies, and then beyond that. He is a leading expert in the legal and societal implications of advances in genetics, and he lectures frequently on the subject throughout the United States and internationally. As a mediator, arbitrator, referee, and appellate consultant at ADR Services, Justice Chin continues to serve the business and legal communities by resolving and continuing to work on complex matters through the growing field of alternative dispute resolution. I'm very happy to have Justice Chin with us today. I could not have been more pleased when I learned that Chief Justice Tani Cantil-Sakauye would join us at ADR Services. As a leader of California's judicial branch of government and as holding the chair of the Judicial Council, her career has been both inspiring and marked by extraordinary leadership. She led our courts through 2 crises, the 2008 recession, which gutted the court's budget, and the COVID-19 pandemic that is now, it's hard to recognize, but is now 4 years in the making. She did so by encouraging collaboration and collegiality on the bench, and by always focusing on improving access to justice, and most importantly, by educating the public on the importance of the judicial branch of government to our democracy. The Chief Justice led by example. She made history as the first woman of color, the first Asian Filipina American, and only the second woman to serve as the state's Chief Justice. Moreover, she's the best public speaker and the most vigorous advocate that I have ever met. During her 12 years leading the Supreme Court, the Chief emerged as one of the country's leading advocates for equal access to justice, transparency, and the reform of state court funding models that have frequently unfairly impacted low-income individuals. Once again, I should know because I chaired the Council's Access and Fairness Committee during many of the years that she has been chief. She was the committee's most enthusiastic supporter, and she answered every call for help. When she became Chief Justice, she opened the formerly closed meetings of the Judicial Council and its advisory bodies to the public, and thus made public comment more accessible to the bench and to the public. When the pandemic hit in March of 2020, the Chief issued a series of emergency orders to temporarily suspend jury trials, extend statutory deadlines, and to allow court proceedings to be conducted remotely, which we'll be discussing today at some length. She worked with other leaders in the court system and across the United States to develop and implement best practices for conducting court proceedings through the pandemic. And this has produced a lot of guidance for us on how to conduct remote hearings. First, to make sure that court facilities are safe during something like the pandemic, but also leading the way to what it certainly is going to be a new era of efficient use of resources. And that's what we're going to be discussing today. Chief has also been a leader in revitalizing civic education through her Power of Democracy initiative, which she developed to inform the public about the courts, both federal and state. Once again, to remind us of the key role that the judiciary plays at every level in our democracy. Chief Tani has continued her public service as president and CEO of the Public Policy Institute of California, PPIC, which is an independent, nonpartisan research think tank for public interest. And it provides data-driven, nonpartisan research to inspire policy solutions for California's challenges. With ADR Services, she is a one-of-a-kind provider of mediations, case evaluations, consultations, and moot courts and mock trials, and far more. As I've said, I could not be more pleased to have both of our panelists here today. I should say, though, that I have been such close friends with them for such a long time. Literally, I met Ming on the very first day that I was a lawyer in my office. So it's going to be difficult for me to remain formal. So I hope everybody will forgive me if I slip into using first names. So let's get started. Chief Justice Tani, of course, you're still engaged in public advocacy, and it's part of the work that you have undertaken at ADR Services. And I would say one of the advantages of working at an outfit like ADR. How have you found your new work? Is it working for you?
Thank you, Justice Lambden, Jim. Thank you. It's a pleasure to be with ADR Services and Ming. It's sort of like old times in chambers together and at the table and at lunch. So I have found the transition to be illuminating. I will say first, I left lawyerhood in my 30s when I went to the bench as a municipal court judge back in 1990. And a municipal court judge is the equivalent today, roughly, I'd say, as a commissioner. I think, Ming, you might have been a muni court judge. I'm not sure. Maybe you skipped that section entirely, same as Jim. But
No, he jumped the queue right up to
he
the
did,
right up
right?
to the
So
Superior Court.
I was 31 when I first donned a black robe and wore it for 30 years. So it's illuminating because I feel like I left lawyerhood. I came back to it now and I rejoined the ranks, and it's illuminating for all of the challenges, but how good so much can be done here and the kinds of cases and policy implications, because at the Supreme Court, at least the last 12 years of my time on the bench, it's been 8,500 cases, petitions for review. So it's been an illuminating transition. Thank you. Thank you, Jim.
And Ming, what are the challenges have you encountered in switching to the other side of the bar? Do the lawyers still laugh at your jokes?
I have found the lawyers that I have dealt with through all of the mediations and arbitrations and moot courts to be superb in every way. And I listened to the two programs, or the two excellent programs that were put on by our colleagues this morning. And Justice Wilhite and Judge Rowan talked about the scourge of incivility that has overcome the legal profession. Fortunately, I have not experienced that. And I certainly hope that the Chief Justice, whom I encourage to do this work, has also not experienced that, because it would make our jobs very unpleasant. So those of you who are out there that think that being uncivil to each other is going to advance your cause, please don't come to our mediations or arbitrations. You will not be welcome. I'm going to give you all one additional reason, in addition to what Justice Wilhite and Judge Rowan talked about. When you apply to be a judge, you fill out a personal data questionnaire. Jim, Tani, you both are well familiar with it. It comes to about 40 pages. You outline everything in your life. The one question that they will ask you, which is most important, list the 10 most important cases in your career. List the name of the judge, list the name of all of the attorneys. You do that, and guess what? The Jenny Commission and the individuals from the governor's office talks to all those people. And they ask them, what kind of a lawyer was Chin? And guess what? They take into account the responses that they get from those individuals who opposed you in litigation. So if any of you think that it's beneficial to be uncivil, disrespectful to your colleagues, think again, because they will have the last say if and when you apply to be a judge. So I really enjoyed the programs this morning. I heard everything I ever wanted to know about AI. So just a word to the wise, Jim and Tani, if you wanted to talk all about AI, they have already heard it. But there are some things that we can add, but I'll let, thank you for your kind introduction, Jim. It's great to see both of you again. I look forward to our conversation.
Well, and I appreciate those remarks. I think we're all in agreement that that warfare analogies are to be avoided in court. You don't need to talk about crushing somebody or putting your boot on their neck or any of the sort of things that we've used to heard here. And I'll add too that it's harder to do in mediation. We have a mute button if we're in Zoom, and also you're sitting, knee to knee with your judge. And we all believe, I'm sure, that you need to leave your opponent when you win, leave them an ability to save a little face. So now that you're both on the other side of the bench, I'd invite your comments on what you think the function of ADR is as part of the judicial process. Is it gaining in importance, or has it always been important? Chief?
Well, thank you. I think it's always been important, but it's gaining in importance even now and will continue to build momentum. And I say that locally, I say it statewide, and I say it globally as well. I've seen an incredible shift, and in the federal courts as well, from cases resolving in the court system proper and moving to, in fact, mediation and settlement. And I say that for a number of reasons. And the first is when I tell folks who mediate with me, here in mediation, you have the ability to have input and craft and control and create the kind of resolution that you would like. You also have an opportunity to speak freely and confidentially in a way that you will not have in a courtroom. And you also have time in a mediation. In a courtroom, it's run hard and fast. When I was a trial judge for 14 years in Sac Superior Court, and when I would have a trial, I'd bring the attorneys in and we'd sit in chambers and I'd say, okay, tell me what we agree on. Tell me where we disagree. Let me focus on where we disagree and let me see what we can resolve. I mean, it is fairly transactional. It just has to be, because a case has to really be worth it in everyone's mind to be using the time and space of a superior court, let alone the Court of Appeal, and really no even discussion about the Supreme Court and our numbers. I also want to say this about mediation and why it's even more important. We're in a growing world, if you haven't noticed, where mental health and civility are all critical. These are the major issues that we're seeing nationally with our governor, with homelessness, with our president, with youth. And so in a mediated setting, we're able to have human contact and for your client to speak directly and closely. And as far as I'm concerned, if you're in a mediation, you ought to get your money's worth. My view is go for every possible explanation that you need. Ask every question. If it's inappropriate, you'll learn that it is in a very civil way, as Justice Chin has pointed out. And mediation is growing because people need and want that contact for resolution. You have input, you have control, you have confidentiality. You get to pick your hours. You get to pick your time. You get to pick your judge. You know, all of us have seen the terror of lawyers when they get assigned to a court that they don't want to be in, and they no longer have any 170.6s, or they don't want to exercise it because the judge is going to find out that it was exercised against him or her. So the ability to actually be the master of your own universe, the captain of your ship, is in mediation. The minute you let 12 strangers and a stranger in a black robe decide it, you are taking a risk that you can avoid. You also are able, and I know surely this is true, you avoid precedent and you avoid publication and precedent of that rule. Lots of cases in courts that have mediated settlement services, like the Third District Court of Appeal and like the First had, and all of the trial courts, there are cases that we just will say, no, they have to go into the public domain. They're too important. But in mediation, you can keep some of those out. It works for your client, depending on who you're interested, who you represent. So I think there are only upsides to mediation. And plus, if it doesn't settle, you get a great evaluation of your matter. Your client has a better understanding, and you'll be going to court better prepared. I don't know, Justice Chin and you have both been doing it longer than I have. I've only been at it for a year, but I am a huge fan.
One thing I remember is having a judge tell me when I was a young lawyer and I was just, having kittens. I was so nervous in court that it's the easiest thing in the world to sit up here on the bench. We get to watch the action. And that's a question I'd ask you, Ming. I find that I get very interesting cases now. You have to kind of wait on the wheel for really great cases when you're on the Court of Appeal. But now people bring them to us. Are you enjoying finding the interesting cases that you used to get on the Supreme Court?
I am, Jim. I agree with Chief Tani that mediation has grown in importance. And I must admit, before I started doing this, I had some reservations. And my reservation is that with so many cases taken off of the court docket, I was concerned that the important cases are not being decided by the courts with written opinions. I mean, after all, we are the only branch of government that explains in detail sometimes excruciating detail, all of the reasons for our opinions. But we are a judicial branch because we do that. I was concerned that so many civil cases are bypassing the courts, but I agree with the Chief Justice that courts and attorneys ought to be able to spot the cases that ought to go to the courts and should be written. If we don't do that, the civil law will not develop. But I think that mediation is an important part of this process. I mean, every case that we settle, every case that we decide is one case that our former colleagues can take off their docket. It seems to me that's an important contribution, reducing the backlog that the courts are experiencing. So I agree with the Chief Justice that the settlement process really doesn't work in front of a trial judge that has 50 cases that they have to get through in one calendar. I remember sitting on those cases, and it's difficult. They don't have a whole day to sit down and listen to both sides, hold everyone's hand, figure out how this case can be settled. That's an important part of mediation. I also think the service that we provide in arbitration is indispensable. Jim, and you and I litigated many of these cases. Some of them we looked at each other and said, why are we in court? Why shouldn't we be in arbitration? Or why shouldn't we be in mediation? So I think it's an important part of the process. I'm happy to be part of it. I'm glad to hear that the Chief Justice is happy, because I don't want to get blamed if she's not.
Well, actually, that's what happened to us on the Court of Appeal more often when we heard that our opinions weren't necessarily the right answer. But one thing that I enjoy telling the parties, and you both mentioned the benefits of being able to talk to the parties directly. One thing I mentioned to them is that it's always been true in our long careers that 95% of cases settle on the civil side because they should. And it's always been true that really the judiciary relies on settlement, whether it's conducted by judges or not. And we have the luxury of time to spend on settlements. And I'm sure both of you do as I do, which is to stick with the cases for long periods and work with the attorneys to settle their cases. It's a lot like diplomacy. And you remember Senator Mitchell saying that he settled the troubles in Ireland with 1,000 cups of tea? Well, you can kind of do that with mediation as well. And I agree that the arbitration prevents precedents from developing. But what I've observed in almost 10 years is that doesn't always happen because it still ends up in court sometimes, particularly if you see it in mediation. Later, I think I'm going to mention a case that I had in mediation that's working its way up to the Supreme Court, I think. And I won't disclose the facts of that. But so we're coming out of a 4-year pandemic tunnel. And it really seems like that. And during the last few months, I've been doing sort of an informal survey of all the attorneys I work with to ask them if they think we're kind of past it and into a new brighter era of litigation. And they pretty much all agree that there's a sense that we've passed an inflection point and that there's a new paradigm in the way we handle cases. I'd be interested to see if you share that we have a sense of opportunity here to continue redefining how the judiciary works, especially in connection with ADR. Tani, do you have any comments on that?
Thank you, Jim. I certainly do believe that we have and are in a new paradigm. And yet I also believe the only way we could have come through it so quickly and so with such cooperation, I'm not saying universal cooperation or universal acclaim, is that we were in crisis. We recognized the need for justice, and we had the foundation of Ming, who had for years been saying to me at judicial council meetings, why can't I do that on my watch? And we, and people at council were saying, well, are we going to dig a hole to drop in fiber optics, or are we going to break through the cloud? And so we are in a new place because we had to be. It was crisis that propelled us. But again, of course, not letting any good crisis not work to our advantage. I crafted with judicial counsel and input, and with Ming's, his mantra in my ear, in my den, 13 emergency rules that just blew past all of the statutes that we had heretofore seen as restricting us in carrying on the people's business of justice in the courts by way of an archaic system that didn't allow us to use technology or recording devices. I mean, there's a statute no longer in existence, but just recently vacated, that required us to use court reporters, report how many electronic devices a court was buying each year, because they didn't trust us that we weren't otherwise tape recording and not using court reporters. But we're in a new place. We couldn't be here without the lawyers recognizing the urgency, the clients recognizing their urgency, everyone recognizing the urgency. Honestly, the difficulty with moving technology in the branch in the past had been primarily three things: resources to buy equipment, unions that thought that equipment meant the elimination of their jobs, and also three, the last piece was the fear that a machine would somehow circumvent, short circuit due process. And the pandemic showed that we could all figure it out, and we would find a way to get justice on the table in many unusual ways. We made and moved law enforcement, legal aid, prosecutors, criminal defense. The civil bar was the most helpful. They, like so many times, have come to the Judicial Council, as Ming knows, as you know, and they would get together and solve the problems they could, and then bring to us the solutions they sought, and then tell us where they needed help. And we were able to craft remote access in that way. We were able to let folks know what we were doing, asking them what they needed, and crafting that emergency rule. And here we are 4 years out, and we survived. We survived well and better than the other two branches. If people recall, during the COVID pandemic in 2020, the legislature went out of business. There were only two branches meeting, the executive branch and the judicial branch. It wasn't pretty. There were no rules. We had no guidelines, but we made them up using due process, respect for people's rights, and we used the utmost civility in the interchange with each other over our disagreements.
There was some inertia. I can remember back when I was trying felonies, Ming fuming over the fact that we had to load the buses full of prisoners and drive them 2 hours starting 3 a.m. to sit in the stairwell all day for a 15-minute arraignment, and then to sit in the stairwell all afternoon before they went back early in the afternoon. In San Diego, I think it was like a 4-hour drive from the jail to the courthouse. That finally went away, and you just explained kind of sort of the inertia that we suffered with reference to that. I also remember
Jim, I want to tell a story that goes hand in foot with your comment. The chief and I did a program in a county up north, and the first thing the PJ took us to was the holding area for the prisoners. They were holding them in the hallway right across from the jury room, and they wanted a new courthouse, so they didn't have to do that. So guess what? I said, why don't you try video arraignments so that they don't have to be here at all? They were horrified. Oh, no, there's no way we can do that. Now, you mentioned in your introduction of the Chief Justice that she shepherded us through two crises. One, the recession, and second, the pandemic. I mean, talk about getting hit with bricks. They totally dismantled everything that we were doing during the recession in the area of electronic filing. As the chief said at the time, we had a Ferrari in the garage and we couldn't buy gasoline to fuel it. So we had to start literally from scratch to build up a digital electronic filing for the court system. When the pandemic hit in March of 20,000, fortunately, we got it accomplished because we had to call counsel and say, you can no longer file paper with us. Everything must be filed electronically. Fortunately, we could accept it. You can no longer come to court to argue your cases. We're going to hear them electronically, remotely. I was happy as a clam. I could now sit here at my desk at home and hear oral argument. I suppose I shouldn't have been quite as happy as I was expressing at the time, but the thing about the pandemic is that it forced us to get rid of the paper, and it forced the attorneys to get rid of the paper. It forced us to get used to remote appearances. I really like them. I like them in mediation. I like them in arbitration. I will make personal appearances if the attorney tells me that Justice Chin, this case will not settle unless they see you eye to eye. I say, okay, we'll do it. I went down to Orange County, and sure enough, it settled. But I had to have frank talks with all of the people in the rooms in order to get that case settled. But the whole, as the chief has said, this paradigm has changed, and the pandemic has forced us to treat people as individuals and not force them, as you say, to come to court to sit around to make a 10-minute appearance. Why are we enforcing people to leave their jobs, leave their livelihood, come and wait in our courtrooms to make a 10-minute statement? We are taking important steps of making the people who use our courtrooms citizen-centric, so that we make it easy for people to use our courtrooms. I think as mediators and arbitrators, we ought to make it easy for people to use and take advantage of our services. And part of that is remote appearances.
Yeah, and some cases, as you mentioned, need to be in person. And I think we all recognize that those occur. I usually, if they've asked for in person, I call them and say, why do we need it in person? And most of the time they convince me that there's a reason. And I agree with you, Ming, that a lot of times you fly somewhere and you do it and you realize, well, really needed to be done that way. On the other hand, the overall advantages are so apparent, and the saving of airplane fuel and rental cars and all the other stuff that goes with the short-term in-person appearance.
So Jim, and Ming, I wanted to say one thing too, that concurrent with remote, but early prior to, is that we were able to get electronic access to records. And it took time because courts needed resources to buy the computers and understand change management. And it's not perfect. But as a member of the public, or even now as a mediator, when I get a case and I haven't received a mediation brief that is all that illuminating, I can go to the public record and I can look up the court and I can see the records. And even if I don't necessarily read them, I know the civil procedure status of them and where they are. Sometimes the parties say this, sometimes they don't, but it just makes for, and sometimes I just want to read in the newspaper and follow up on what has happened here. And we have the ability now to go into any county. It's a little harder. They need to be more uniform. Goodness knows they need to be consistent. They need the same interface. They need a lot of things, but I can, and you can, and the public can click their way through to get to the motion for summary judgment and learn that it was denied. It's a new world in terms of the ability to have information as you need it.
And we can also look up the parties. I mean, you can look up this corporation and discover what they've done, or the individual to see, their trail. Of course, they do that to us too, which is, turnabout is fair play. I was going to mention too that when Chief Tani was appointed, we were just coming off a big struggle over trying to set up a statewide computer system. And I think that's where the comment about the Ferrari in the garage without being having any gas came from. But now we've overcome that kind of in one fell swoop, where we now have electronic filing. We now have a more integrated system. So comment on that. Is the state system 58 county wide now working on all cylinders?
Well, Ming can speak to certainly the Ferrari, because I think he was the car manufacturer along with some Court of Appeal justices.
I mentioned too, he does like cars. He always has.
Oh, he does. I know this. And I will say now, what really put us on the map was the ability during a horrible budget year, and Governor Brown grumpily told me, you're not getting any base funding. Don't look like I'm going to build your budget, but I will give you one-time money. It's, sort of like your bonus. You get a bonus this year. You won't get it next year. And so we asked him to give the judiciary innovative grant fund. We made it up. Governor, we need integrative grant funds. Well, what are those? Just money to the trial courts to experiment. And then the legislature said, well, it has to be tech, it has to be this. And so we were able to give all of the counties, the 58 trial courts, seed money to build something that has based in technology that served the public. And that got us going. And to your question about how is it now? Oh, it's a patchwork quilt, but it's an improvement. It needs a lot of work, but it's an improvement. And most of all, we've changed the mindset. We've changed the narrative. And attorneys and judges have built new skills with accessing and bookmarks and filings that are actually we're not ahead of any state. We're barely keeping up with some states, and some states are far ahead of us in how they use remote technology. And we need more uniformity. And we need the input from the lawyers who use the system to tell us what's wrong with it. That's a really big part. Is the judges think it works fine because we get what we need, but you need to tell us where we need it, and also what counties are struggling so we can direct support to those counties.
I really like your comment that we're now looking at it not from our point of view, but from the outside in on how we approach. Yeah, Ming.
Jim, it's a patchwork quilt because the legislature said you can't have that Ferrari. We're not going to give you gas for it because we were designing a statewide system. So
and we did have the plans.
We had the plans,
have the money.
and we were almost there. And Orange County was there.
Yeah,
they were the first county. They were ready to go. But at any rate, I want to comment on the innovation grants because it was one of the Chief Justice's sterling moments getting that money from Governor Brown. I could not believe it, frankly, but she got it, and it worked incredibly well. I mean, I had to sit next to the Chief Justice in all of those Judicial Council meetings, and it became a real pleasure because at every Judicial Council meeting after she got the innovation grants from Governor Brown, we heard from various counties about the progress they were making with those innovation grants. And it was really exciting to hear what the counties were innovating in their various counties. And we kept detailed records of each program so that it could be duplicated in other counties, which happened. So I think that one-time money that the chief got from Governor Brown was a real savior for the judicial branch.
All of us appreciate the relentless charm exhibited by Chief Justice Tani, and it worked even on Governor Brown. Now, let's talk about the big picture. Has the switch to remote actually helped with some backlogs? Are we in better shape than we were before because of the remote access? One of the handouts that we are using is the operational metrics from the report that came out on January 12th from the council in terms of the statistics on the courts. Do you have any comments, Chief, on the accomplishments that we can pat ourselves on the back for?
Yes, and I think the accomplishments were collective, and you don't have accomplishments like this unless you plant the seeds, unless you have someone, who's always constantly saying, we need to improve, we need to be modern, we need to have access technology. And Ming has always been that throughout. And surprisingly to us, remote technology cleared backlogs. It made some disciplines current, particularly in family law, for example, because we were able to schedule hearings online and families could attend with, as both of you said, the least amount of disruption to their work, to their care, to costs, and families who were interested could beam in from other parts of the state or the country to listen, to be a part of, if someone needed some support, if the court agreed. So in family law, we saw actually the caseload get caught up and current. And the same was true for juvenile dependency and juvenile delinquency, partly, I think, because young people were more comfortable appearing on a screen such as this in the comfort of their kitchen than going to a courtroom. All of us have been in a courtroom. Some of us have been in it so often we don't think of it as an intimidating place, but it is an intimidating place to many. And so we found that remote technology it allowed breakout sessions and attorney-client privilege discussions, and to bring in other people and interpreters. It made a huge difference with family law, juvenile law. Where we saw the most difficulty, to be honest, was in criminal law and civil, but primarily criminal law. And that was, I think, perhaps in the beginning, well-founded, with concerns over the ability to be fully fair and due process, and the ability to actually be heard in criminal cases. And so there was a huge backlog. Courthouses, as you know, were unlimited functionality, and we had closed courtrooms. And where we were fully open, we had to spread everyone out by 6 feet, then 3 feet, then 2 feet, and by floors. So we couldn't function at full speed. And so we experienced a backlog in criminal, a backlog in civil. What helped us stay out of trouble with the law and the statutes and the Constitution was that Governor Brown gave an executive, or Governor Newsom gave an executive order to the Judicial Council and myself that allowed us to suspend statute. So my emergency rules were otherwise against the law, but for the fact that Judicial Council had the governor's executive order authority under time of emergency to suspend. So we went to the civil practitioners and said, what do you need? Extend the 5-year rule, extend the 3-year rule, allow remote. And yet in criminal law, because people were often in custody and those who could be released we had to continue jury trials or suspend them, or same with prelims. And so we experienced a backlog in criminal law, a little bit in civil, but not as much as we have and did in criminal law.
And Ming, sometimes wishes can come true. Are you satisfied that remote is here to stay?
Oh, Jim, I'm an optimist, but I'm not that much of an optimist. In Sacramento, there has been an added push not to do it, and it comes from various sectors. I had an arbitration with experts from all over the country testifying remotely. I can't tell you how much better that process is than having expert witnesses take their valuable time to fly to California from New York or Chicago or New Orleans, sit around in our courtrooms for hours before they testify. They can be in their labs, they can be in their offices, testifying remotely just as effectively. So I'm a real fan of remote appearances. And I realize that I may be alone in that analysis, but I just think we waste so much time of people with valuable information that can get it to us in a much more efficient way. And I think we ought to, as a system, try to expedite that. So I think expert witnesses is an important area that the branch and in arbitration we ought to keep in mind. We can also have hybrids so that some of it can be in person, some of it can be remote. And I think expert witnesses are a good candidate for remote appearances.
Yeah, we can make the solution fit the problem. And I'll mention an example of that is that another thing is that we've discovered, I think you have too, that there are a lot of things out there that we never knew were possible to be done in ADR. I've been doing peer review hearings for doctors accused of misconduct in hospitals. And those formerly took years because you have a panel of a half a dozen doctors that have to be assembled with several lawyers. And to get them on the calendar takes months, just simply because they're so busy. I did one the other night where I had experts in Chicago, Pennsylvania, New York, and San Diego. And we were able to do that without everybody flying all over the country. So you can see in something like a medical malpractice case where time is valuable, a surgeon on call needs to be available. It solves so many problems. Another thing that I wanted to ask about was interpreters. We've always had a difficulty finding interpreters for the 120 plus languages that come into our courts. Are we having any success, better success with that you're aware of, either of you?
I'm aware that we have launched several pilots to use interpreter services remotely. And again, it's a little bit of form over substance, because 14 years ago, and all of you, we were in trial, we were in arraignment courts. We were places where it's 4:45 in the afternoon, and you need a Tagalog interpreter for someone in custody. And I'm in Sacramento, I can't find one, and they want their daughter to interpret. And so we would call someone at that point and say, could you please interpret that we're just going to continue this or they're going to be released? And we were able to take care of it. But somehow, fast forward some 15 years later, and all of a sudden there's an objection to using interpreters by phone or by video. And we know in practice it happens, but no one wants it to be something, not no one, but there's a group of folks who don't want to see it organized or routinized. And, when I dig down, and this is just me, and I can say this now because I'm not the chair of the Judicial Council, it was fear again of losing their job to a practice that was automated or telephonically used, or maybe you don't need as many court interpreters now because they're at a hub, and at the hub you can have FaceTime or a video. And so we were challenged in the branch with using interpreters and video. And yet we were using it primarily, rather successfully, for sign interpreters. And we tried to run pilots in different regions of the state to quell everyone's fear that somehow we were violating people's rights. And we got a lot of pushback that it's just not the same as being in person. Of course, it's not the same as being in person, granted. But the real question is it still substantively fair? Are you still substantively getting what you need? It was very emotional. And then it kind of morphed into contract interpreters get paid more than court interpreters who are employees. Then we morphed into a whole pay raise by region, because it was a big issue and it was hard to separate out remote use, telephonic use of interpreters without addressing pay inequity, without addressing a lot of issues, employment stability, just all morphed into a big problem. But we have run pilots, we continue to push, and I believe it's more normalized now. It's still not widely accepted because people still believe the gold standard is when you're wearing that big contraption on your ear and they're wearing their big contraption and they're huddled at the table and there's a lot of buzz, but you're acting like you can't hear it because you're not supposed to be listening. They still seem to think that that is the perfect way to go, but we're pushing in that direction. And I think ADR, with its use of, as you both said, experts in different parts of the country and world, and also we're showing lawyers that it's not anything to be feared. It's something good. You can use it to your advantage. And as an option, it's good for us, good for you 90% of the time.
I promised an example from one of my cases that illustrates both the problem and the solution. And again, it comes from the healthcare model. I had a case involving a California company that arranged for interpreters around the nation in emergency room settings. So we have a hospital in Minnesota that needs a Spanish interpreter and sets them up, and the California company sets them up with an interpreter in Texas. And the issue in the case is that subject to California's employment laws, so that a class action could be developed nationwide that would be subject to California's employment laws. So you can see the can of worms that opens. The interpreters in Texas don't want to have anything to do with it. The court has to decide whether or not the law applies. And I think it's in the works headed up to your former court at this point. So there are so many moving parts here. Do you see any other problems, Ming, with reference to something like that, where you've got a nationwide network that has to be managed state by state?
Well, I think that the solution that the Chief Justice mentioned is a solid one, to have a hub of court interpreters that anyone in the state can call into to get an interpreter of any one of the 120 languages. Rather than having all these interpreters traveling for hours throughout the state or the country, come on. It seems to me that that's at least a reasonable solution, but you have to get everyone to buy into it. And you're not going to get people to buy into it if they're about to lose their jobs because of this process. And this goes to the other matter that you wanted to talk about in this discussion. And that is, what effect will artificial intelligence have? It will force people out of many jobs because the routine matters that artificial intelligence is going to take care of is going to put somebody out of a job. So we have to have a process. If we go into this and use it throughout the state, we have to have a process to upskill individuals who are in those positions so that they will learn new skills that will be beneficial for the new economy. But if we don't do that, a lot of people will be out of work. So that's one of the effects that artificial intelligence may have. We just heard a terrific presentation by Judge Wilhite of what is happening in the area of artificial intelligence, what the State Bar is doing. I only want to put a footnote on it. In the State Bar papers, they cite to an MIT program twice. And they get from the MIT program many of the solutions that they are talking about in solving AI. On March 21st, MIT is going to have another program on AI. There is also a report from the World Economic Conference that was held at the Presidio in San Francisco, where they came out with 30 recommendations of what should be considered in handling AI. So there are lots of people talking about it. It's an important concept. It will have a great effect on our judicial system and our ADR system. So we have to pay attention to it, and we have to participate in those conversations to make sure that we have an input into the benefits and risks of AI, particularly when you have, in the Mata case, where some attorney is filing an AI brief in front of a New York court with phony briefs, with phony citations, with phony facts. We cannot have that in either our briefs or the briefs that are filed in our courts. What a novel concept that before you file something before the court, you ought to cite check it. We ought to impress that on any attorney who is listening, whether they use AI or not. Cite check to make sure that your citations are accurate. Oh, by the way, if we ask, by the way, Jim, if we ask a question of our audience, we have to tell them that in billing for AI, they cannot bill for the time they save in using AI.
Yeah, that's already in the rules.
What a novel concept.
Yeah, that's already in the rules. It's also been mentioned that there's no reference in the rules of professional conduct to technology. But in fact, there is. There's a March 22 comment that remarks that it's a matter of competence under Rule 1.1 to keep up with advancements that affect your practice. So it is
Advancements
important.
in technology.
Advancement in technology uses that actual word. And some of the things like you can't use a robot and then bill for that time should be sort of a duh question, but nevertheless, it's true. Thank you for getting us back on track, because we did at least publicize this as being somewhat about AI, and as often happens, somebody took our thunder this morning. But
And
we
they did an excellent job, by the way.
Yeah,
I thought,
and we don't need to go there, but you can see it coming. We're going to have MCLE requirements. We're going to have a look at the bar exam. I suppose they mentioned this morning that robots have passed the bar exam. In fact,
and the medical boards and the
medical boards
exam.
and the MBA tests and everything else. So the examiners, the bar examiners, are going to have to be looking at that as well. So the takeaway, I think you agree, is we got to have a 3-branch solution. We have to have a 4-branch solution because ADR is going to have to be included. And we're going to have all the stakeholders at the table to make this work, because they're going to be vested interests that push back, which may include even the robots themselves. My last question that I was going to ask you.
Go ahead. Can I just say one thing too? Yeah. California has long had a justice gap problem where we have for every 7,000 residents of California who are below the poverty line, we have something like 1 legal aid lawyer. And we've tried various ways in California throughout history to try to bridge that gap, including considering mandating pro bono hours, including mandating and looking into devoting at least some of those hours to service. We've also looked at how technology can fill the void in terms of answering like a WebMD. So I guess it would be Law Esquire, whatever it might be. And we have to be clear in getting ahead of this, that the legislature's answer to some of this might be AI.
Well, and they need to consider, among other things, whether or not to say AI can be the unauthorized practice of law. Very interesting questions raised here. That's where we wanted to end up, with sort of a last word on what to expect in the future, and we can see it's going to be a very interesting future. I think we're pretty much out of time. Go ahead, Ming.
I just read my Sargon opinion because it's right next to my Continental Insurance opinion that the chief and I are working on. And I actually said in Sargon that the future is very difficult to predict. But I'm going to make a comment about the use of CRISPR, because I did a CRISPR program for Rudder, and CRISPR, without getting into the weeds, it is a gene therapy that Dr. Jennifer Doudna perfected to go into our DNA, extract a mistake, and insert the correct letter. Example, sickle cell anemia is caused by one mistake in the genetic alphabet. Dr. Doudna developed CRISPR to go in and extract that letter and insert the correct letter. A year later, the woman is cured of sickle cell. This is the future. The FDA just approved the CRISPR process to use in sickle cell. So this is a step into the future that can be absolutely incredible. Jennifer Doudna won the Nobel Prize for her work on CRISPR. She is a scientist at UC Berkeley. She grew up in Hawaii on the island of Hilo. When she was a junior in high school, she approached her science teacher and said, "I want to study science." The teacher's response was, "Science is not for girls." I wonder what that professor is saying now about science not being for girls. Jennifer Doudna is the first woman from UC Berkeley to win a Nobel Prize.
Well, and let's see if we can do something similar in the judiciary. Thank you both for your comments. This was wonderful.
Yes, thank you everybody for sticking around for a couple more minutes. And thank you so much to our panel of speakers, former Chief Justice Tani Cantil-Sakauye, former Appellate Justice Ming Chin, and former Appellate Justice James Lambden for moderating our panel this afternoon. I really appreciate all of your time and your insights, sharing all of your thoughts about the future of the ADR industry and your experiences so far with ADR Services, Inc. We're so pleased to have you on our panel, and so much appreciate the work that you do with us and for the judiciary as a whole.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront, woman-owned and operated from the start. There is someone for every situation. We are ADR Services, Inc.